But in this case is that whether the Supreme Court of India has the jurisdiction of this hear the writ or not. So, my lordship, the Honorable Supreme Court of India now does not have the jurisdiction to hear this writ because, my lordship, the Honorable Court of India now has lacks of jurisdiction to hear this writ because the triple talaq is governed by the personal law under the Muslim personal law, that is Sharia Act 1937, protected by Article 25 itself. This is mentioned under Indian Constitution. And also, my lordship, the scriptures and customs, judicial interference is unwarranted as no constitutional violation exists. The writ petition is not maintainable, and therefore the writ petition should be dismissed. So, my lordship, may I want to proceed the second issue of this case? So, my lordship, the second issue of this case is that whether the practice of triple talaq, that is talaq is a part of Sharia or not. So, my lordship, I strongly believe that in the light of this fact, the practice of triple talaq is not only an integral part but also an indispensable part of the Sharia. Because, my lordship, while the petitioner contends that triple talaq is confined solely to the Hanafi school, but this argument is both misleading and distorted because Islamic jurisprudence, that is known as fiqh, is rooted or rich tradition comprising four major Sunni schools, that is Hanafi, Maliki, Shafi and Hanbali, which together form the backbone of Sharia, and for over 80 to 90% of the Muslim population worldwide follow these schools. And my lordship, the founders of this school is all, that is Imam Abu Hanifa, Imam Malik, Imam al-Shafi and Imam Ahmad Ibn Hanbal offer comprehensive framework that he guides Muslim personal law for centuries to isolate triple talaq as a practice exclusive to one school is to ignore the broader jurisprudential reality and the historical legitimacy of these diverse legal interpretations. So, moreover, our constitution under Article 25 protects the religious freedom, acknowledging that personal laws, including those derived from the Sharia, must be respected so long as they do not violate the public order, morality or faith. So, my lordship, the petitioner also heavily relies on the sayra of the Union of India 2017 case. But the challenge people but it imperative to be recognized that the judgment was a split 3-2 decision. So here, my lordship, Chief Justice J.S. Kehar and Chief Justice Abdul Nazir dissenting, firmly stating that the court has no authority to determine its validity as it falls within the domain of Parliament. So this underscores that Muslim personal law deeply embedded in the four major schools, that is Sunni schools, not merely a practice but an essential pillar of Sharia, and upheld the overwhelming majority of Muslims. Moreover, my lordship, it is important to highlight a hadith where Allah expresses strong disfavor of triple talaq among the permissible matters, but a sentiment also emphasized by Prophet Muhammad. But, my lordship, however, while it is disregarded, neither Allah or nor the Prophet so ever declared it to be outside all of Sharia. So this itself serves as undeniable proof that triple talaq remains an integral as well as an indispensable part of the Islamic jurisprudence. So, lordship, may I want to proceed the third issue of this matter. So, the third issue involved in this case is that whether the practice of triple talaq is constitutionally valid or not. So, my lordship, the petitioner attempt to portray triple talaq as unconstitutional is a fundamental misrepresentation of both constitutional and religious jurisprudence. The mere existence of the provisions in personal law does not make it unconstitutional unless it directly contravenes the contravenes the core tenets of the Constitution, and triple talaq deeply rooted in Islamic tradition and protected under the Article 25 itself with the Indian Constitution, stand as a religious practice beyond the judicial interference. So, my lordship, may want to give an example. So, my lordship, there is a section under old IPC, Indian Penal Code 1860, section 125A, sedition. So, this is the upheld in landmark cases such as Kedarnath Singh versus State of Bihar, to continue to exist a constitutional relic of our colonial past. So, furthermore, my lordship, when the discuss section 2 of the Muslim Personal Law Sharia Application Act 1937, particularly in the context of the triple talaq, there is a deliberate attempt to conceal of the crucial aspect of the Islamic divorce, that is includes Qur'an and Muharram, where the both parties are agreed to dissolve the marriage. So, my lordship, In the light of the summary of the arguments and authorities cited, the respondent humbly plead before the Honorable Court in light of the facts and arguments presented is the most respectfully plead that the Honorable Court declares triple talaq, that is talaq that is not an only integral part as well as the indispensable part of the Indiana's Constitution, and also my lordship the Sheriff and upwards section 2 of the Sheriff Act 1957 as absolute constitutional beyond any doubt or challenges.